So mediation is a process that is part of the court process where a neutral individual, typically an attorney, somebody who was a divorce attorney and has since retired, or continues to be a divorce attorney and is also an expert in conflict resolution, or sometimes not an attorney, but is an expert in conflict resolution, sits down with both parties and their attorneys, sometimes without the attorneys. And they try and resolve the pending issues in the case. So the mediator identifies what do they agree on, what do the parties not agree on, and then kind of goes one by one with the issues that the parties don't agree on and tries to resolve those issues. Now, the benefit of mediation is that it can narrow down the disputes and allow the courts and the attorneys ultimately, because ultimately the case has to go through court, to more quickly resolve the litigation. Okay, because instead of fighting over 10 things, over 3 years, we're going to fight over 1 or 2 things over 6 to 12 months. So that's a way that mediation can help. Mediation can also be a double-edged sword, because sometimes people give things up in mediation that they really wish they had fought for if they had understood that maybe those things would have been much easier to win in court than they believed they were likely to win or lose in mediation. And this is where it's essential to have an attorney who understands the court process, who knows our judges, who's been before these judges dozens of times, and understands how likely it is that they're going to award one thing over another, to be informing the client with regard to their rights and with regard to what they're likely to win or lose in court, so that they don't give up things in mediation that later they spend years regretting and feeling upset about, and feeling that maybe they hurt their children or they hurt their finances because they agreed to something in mediation that really was not in their best interest. So litigation is the process of going to court and fighting over issues that are pending in court. So we file motions. There's responses to the written motions the other side. These motions are verified by the parties, meaning that they're essentially under oath. Everything that's written in these motions and these pleadings, these petitions, these court documents are essentially sworn statements. So you have to make sure that they're exact and precise, and they represent what your interests are and what your goals are. And then there's hearings that occur in court based upon these motions. There's testimony, there's evidence that's presented. There's also something called a pretrial, where the attorneys go and meet informally with the judge and explain, advocate the issues, and the judge comes out and gives a settlement proposal. Pretrial is often a very quick route to getting a case resolved, in fact, often sometimes quicker than the mediation. And so these are the court processes, right? The battle in court, as it were. Now, it's important also to notice that the whole dog and pony show that you see on television, with the trial, first of all, you don't have juries in Illinois in divorce cases. Your judge is going to decide everything. At the same time, what goes on in court is a process that you need to understand every single stage and know what is the strategy of the overall process in the case. So litigation is complicated. It involves these motions, these hearings, these trials. And mediation is a way to resolve the case without the protracted litigation, right? It's just one meeting, sometimes 2, sometimes 3, where a facilitator, an expert in conflict resolution, is going to meet with the parties, try and resolve the pending issues.